Now we can turn to the second perspective of the relation between international and national law. From a domestic perspective, we can ask whether, in principle, international law is law to be applied or fact to be observed. If it is law to be applied, a judgment could be based on it. Clearly, from the domestic perspective, international law is law. On this point, we can again rely on the underlying logic of a state's intentions in being involved in making international law. In the ILO, for example, states, along with employers and workers' organizations, make international law treaties with the intention that they should be binding and applied nationally once ratified nationally. Seeing international law as a mere fact would be contrary to the state's involvement in making the international law. Of course, we have to quickly step in to say that from the national perspective, we can observe that national rules are used to determine how and when, that is, under what conditions, the international law is to be applied. And this starts to take us to the entrance of our study of how international labor law can be used nationally. The essence of national rules about using international laws turns on whether international law is seen as part of or separate from domestic law. Note here that in either case, international law remains law to be potentially applied. The two ways of looking at international law from the domestic perspective are called monist and dualist. The monist approach sees binding international law as automatically being part and parcel of domestic law, ready to be applied in resolving a dispute in a domestic tribunal once the state has accepted the international obligation to do so. International law and national law, in other words, are one unified body of law. Where this is the case, we can begin, of course, to speak of hierarchy of law. Just as legal orders composed entirely of domestic law needs to have rules about hierarchy of laws in order to resolve situations where laws are inconsistent, these rules need to take account of binding international law when it is seen as an integral part of the controlling domestic legal order. The dualist approach, on the other hand, sees binding international law as being separate and apart from domestic law. Where there is a dualist approach to the relation between international and national law domestically, the state requires domestic action to bring international obligations within the body of law that is applied in deciding disputes in a national tribunal. Keep in mind, though, that upon acceptance of obligations, international law is binding on the state seen from the international perspective. Transposition or translation are words used to describe what is needed under the dualist approach to make binding international law cognizable internally so that it is valid and can interact with domestic law, ready for application in resolving a domestic dispute. But a single word like transposition really belies the reality that approaches of domestic legal systems today have both dualist and monist elements. There are few examples of pure dualist or monist approaches seen from the domestic perspective. We can see the example of a very dualist country like the United Kingdom, where an international treaty ratified by the government has no effect in municipal law until an act of parliament is passed to actually give effect to it. This can be compared to several other countries of the common law tradition with its strongly dualist approach. In the US, for example, the Constitution says that once the president enters into an international treaty with the approval of 2/3 of the Senate, the international law becomes the supreme law of the land. But to return to the dualist situation in the UK, as you will learn, there are ways and examples of instances where international law is validly brought to bear on decision-making in domestic courts of countries with even strongly dualist approach. And if we consider strongly monist countries, like many French-speaking countries in Africa, in many of these countries, international treaties must be published in order to be the basis for decision in a domestic court. Without formal publication, they simply are not the law of the land, despite a monist tradition. And in another moderately monist country, the Netherlands, both approval by the parliament and official publication is required before international law has internal effect in domestic tribunals. It is worth noting that there is no international rule speaking to whether states should be monist or dualist. The 1969 Vienna Convention on the Law of Treaties is international law, and it speaks about the obligations of states under international law. For example, that every state possesses the capacity to conclude treaties and that domestic law cannot be relied upon to justify a failure to perform under international obligations. But it is for individual states to decide how they will give effect to international obligations using a dualist or a monist approach or something in between. It is interesting to keep in mind that from an international perspective, performance of the international obligation to apply international rules domestically is automatic where the monist approach prevails. Of course, actual government actions can still breach international law obligations, but where monism prevails, international law is de jure domestic law that needs to be respected and can be enforced in domestic courts.